Good afternoon, everyone. If you could find your seats, please. I'd like to welcome you all to the 2025 Moot Court National Championship. My name is Jen Frater, and I've had the privilege of serving as tournament director for the qualifying Moot Court tournaments this season online. It's been wonderful to meet many of you in person, and I'm honored to introduce this round today. I'm sure our competitors are eager to hear which side they are on. And as petitioners today is David Drummond and Mary Crosby, and our respondents are Olivia M. and Derek Sun. You guys may begin to prepare your tables. And we can congratulate them while they do so. While they're doing that, here's a few reminders. The justices for today's round will arrive at the back of the room. I'll read their biographies, and then the clerk's going to begin the round and walk them down and bring them up to the stage. Just a reminder to silence your cell phones and refrain from entering and exiting too much during the midst of the round. Try to do that between speeches. So we'll give these guys just a minute or two to get settled. I'll pray with them, and then we'll hear about our justices today. All right, I'd like to introduce the justices for this round by reading their biographies. First, we have Justice Thad Burson. Justice Burson is an NCFCA alumnus who competed in moot court, team policy, and all three speech types. Mr. Burson recently graduated from Cedarville University in political science after studying a semester abroad in England and competing on the forensics team, mock trial, and Model UN teams. He will begin law school in the fall at Georgetown University. Thad enjoys hanging out with his younger siblings, with special attention to his younger brothers, playing spike ball, and reading. His favorite books include Surprised by Joy, 21 Servants of Sovereign Joy, and any Jane Austen book. Thank you so much, Justice Burson, for being with us today. Next, serving as our Chief Justice is Michael Coxon. Mr. Coxon is a partner at the Minneapolis law firm of Faegre Drinker. He earned his bachelor's degree from University of Wisconsin. He attended law school at George Washington School of Law. He led a pro bono trial team in a building side tenant remedies case on behalf of a nonprofit tenant advocacy organization against one of the largest private landlords, winning a record-breaking rent abatement order. He's been married for 18 years and has 4 children and 2 Labradors. His hobbies are guitar, photography, tennis, and road biking. Mr. Coxon serves as the Carver County Conciliation Court Judge as part of Faegre's pro bono program. Thank you for being with us today, Justice Coxon. And our third justice will be Justice Melanie Corley. Mrs. Corley earned her bachelor's degree in business administration from the University of Texas in Austin, where she also attended law school. As an attorney, she worked with victims of domestic violence as part of the VAWA-funded task force. Her current full-time position is running a disaster recovery company. She loves Zumba and writing extemp questions. She's been married for 25 years and has 5 children, ranging in age from 16 to 29. Her favorite book is Rich Dad, Poor Dad, and she has tons of mom phrases that she has repeated for so many years that the words will ring through her children's heads forever. Thank you so much, Justice Corley. And now, our clerk, Mr. Caleb Formo, will begin the round.
All rise. Oyez, oyez, oyez. The Supreme Court of the United States is now in session. Honorable Chief Justice Coxley presiding. All those having cause to be before this honorable court, draw nigh and pay heed. God save the United States, and God save this honorable court.
On the docket today is Taryn Bellator, Petitioner versus the State of Frankfurt. Respondent, is Petitioner ready? You may proceed.
Mr. Chief Justice, Honorable Associate Justices, and may it please the court. My name is Mary Crosby. My co-counsel, Mr. David Brummins, and I represent Taryn Bellator, the petitioner in this case. At this time, I'd like to reserve 3 minutes for rebuttal. Thank you, Your Honor. My co-counsel will be addressing the issue of the Fourth Amendment violation, but first I will be addressing the First Amendment issue. Our client is a first-generation Atlantean American. Like other Atlanteans, he views the island of Olympia as his historical homeland, a homeland that is currently under attack by the Olympian government. Yet when Mr. Bellator called out for the freedom of his nation, he was arrested, fined, and charged with a second-degree misdemeanor. This court should reverse the decision of the Supreme Court of Frankfurt. Siding with the state would have a chilling effect on political speech, which this court cautioned against in Virginia versus Black and Counterman versus Colorado. It would also greatly harm our ability to speak without fear of misinterpretation and government censorship. The petitioner's speech does not fall under any categorical exception to the First Amendment, those being incitement, true threats, and fighting words. In Brandenburg versus Ohio, this court decided on a test to determine whether speech qualifies as incitement. Speech is unprotected when it is, quote, directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Inciting speech has 3 defining qualities. First, it must have been directed or intended by the speaker to cause violence. Second, the violence it calls for must be imminent or near at hand. And finally, violence must be the likely result of the words chosen. First, we must examine the direction or intent behind Mr. Bellator's speech. The words "from sea to sea, Atlantis shall be free" could be interpreted several ways. This makes a ruling for the state impermissible because they cannot speculate with certainty on the intent behind an ambiguous chant.
Are the words the only thing that we can determine intent by?
Your Honor, we would not say so. We would say that even the facts of the record that the respondent is likely to point to would also not point to Mr. Bellator's intent. We must look to the context of the situation, but even that here fails. The respondent will likely point to the context of the private statements brought forward by Mr. Bellator. However, we do not believe those point to his incitement, and that's because of several reasons. First of all, it requires the state to read into the meaning of the phrase intent. It is impossible, nearly impossible, to read into Mr. Bellator's private statement any intent to cause violence towards those present to him. And the reason for this is to take his statement in the most literal context, would be calling for death to those present. However, Mr. Bellator himself did not engage in any violence whatsoever, as noted on page 4, paragraph 2 of the record.
How many protesters were there?
Counter-protesters or protesters that were pro-Atlantean, Your Honor?
Protesters.
Yes, Your Honor, there were 300.
How many of them were armed?
Your Honor, the record doesn't state how many were armed, but you are correct, they were in legal possession of firearms and other illegal weapons. However, that does not point to Mr. Bellator's attempt to incite, as Mr. Bellator, nor in the record does it say had any knowledge that these individuals were armed.
He's the president of this organization. You're saying he had no knowledge that anyone was armed?
We're saying the record is silent on that issue, Your Honor, but we know from the record that Mr. Bellator himself did not have any illegal weapons on his person at the rally, and so the possession of others and weapons does not point to his possession or his intent to incite, would be our argument.
And that's just his say-so, right? The police didn't catch up with him until 7 o'clock that night.
That's correct, Your Honor. However, Mr. Bellator, nowhere in the record does it seem to have a weapon on him. They found a weapon in his drawer, but they did not find it on his person. Nowhere in the record does it say that, Your Honor. But further, even if the...
Could we infer intent once he keeps chanting in light of the violence that's going around him?
The respondent is likely to make the argument, Your Honor, but we would disagree. We'd actually say it points further to Mr. Bellator's belief that his chant was protected rather than his belief that he wanted to incite violence or wanted violence to occur. It actually points more to the fact that he believed his words were protected under the First Amendment, that the police did not have a right to tell him to cease his chant and set down the megaphone.
Forget about the First Amendment for a minute. If he understood the causal relationship between his chant and people getting excited and violent, doesn't he have an independent duty to knock it off, irrespective of whether it's protected?
If he did understand that causal link, Your Honor, we would agree with you. However, we argue that Mr. Bellator did not see that causal link for several reasons. First of all, that violence only resulted 3 to 5 minutes afterwards. The record notes that Mr. Bellator's counter-protesters and protesters were agitated at his chant, but not that violence resulted until 5 minutes later. Further, yes, Your Honor.
Does your argument change if he had said, not privately, but publicly among the chanting, we need to make these genocidal murderers feel the violence they inflicted upon us, and death to the murderers? If he had said that on the bullhorn, does your argument change?
No, Your Honor, we'd still argue that it does not.
So that's okay too.
Your Honor, we would say...
What would he have to say to be a problem under the First Amendment?
Yes, Your Honor. That's pointed out by the case of Hess versus Indiana, which speaks about how speech must be directed towards imminent lawless action and must be directed towards those present. Mr. Bellator's speech did not have any directed to those present.
We need to make the genocidal murderers feel the violence they inflicted upon us. How is that not a present tense statement of, go do this, guys?
First of all, Your Honor, we'd note that genocidal murderers would be implausible to connect to the counter-protesters, as nowhere in the record does it note that they are ethnic Olympians themselves, and it is only Olympia and the state of Olympia. Yes, Your Honor.
The counter-protesters are certainly aligned with the genocidal murderers, if not genocidal murderers themselves, correct? Just by virtue of showing up to counter-protest.
They show support for them, Your Honor, that's correct.
And you don't think they felt like perhaps they would be linked to the genocidal murderers they're supporting?
We would argue no, Your Honor, because Mr. Bellator was not calling for violent action towards those who support Olympia, but rather the individuals themselves. What the record notes is that Olympia is viewed as a nation of genocidal murderers, not that non-ethnic Olympian counter-protesters in support of the nation are themselves those people that he is referring to in his private statement.
Doesn't that seem like a fine distinction?
We would not say so, Your Honor, specifically because a chant must have explicit language to be able to link an individual's directive to the violence that resulted. If that does not occur, it is very easy for the state to do what they will probably do, which is link several facts in the record as showing Mr. Bellator's intent. However, that is a dangerous standard to uphold, as it is government reading into Mr. Bellator's intent, even though his explicit statement was that he did not intend violence to occur and would set dangerous precedent for the court. But further, Your Honor, we would point you to the ruling Hess versus Indiana, which showed that Gregory Hess's speech, "We will take the censored street later," was not incitement because, quote, "at worst, it amounted to nothing more than advocacy of illegal action at some indefinite future time, and this is not sufficient to permit the state to punish the speech," end quote. Your Honor, Mr. Bellator's directive did not specify any time frame, and also, Your Honor, it was a statement that his own side does not see as a call to action, but rather a figurative statement.
Okay, but in Hess, you're dealing with a one-time statement. The protest already is going on. He makes this one-time statement like, we'll be back, we're gonna take this street. Here, in this case, he's chanting this for hours on end. He's chanting this as they're trying to get him to stop and arrest. How is Hess comparable to this case?
Yes, Your Honor. We would say so because just as Gregory Hess's speech was protected, Mr. Bellator's speech was protected the first and last time he said it in those 34 minutes. And that does not change whether or not police officers ask him to stop chanting. That would invoke a heckler's veto, something this court does not support. Your Honor, a ruling for the petitioner would be in line with decades of court precedent in favor of a speaker's right to free expression. Mr. Bellator's, yes, Your Honor.
The private statements, are those admissible evidence for his intent?
They are something for this court to consider, Your Honor, but we do not believe they point to
I understand that, but you're not arguing that they're not admissible for the court or the jury to consider below.
No, Your Honor, we are not making that argument here. Your Honor, the ruling for the respondent would chill speech, making many less likely to speak out, and create a dangerous system where our First Amendment protections only exist at the behest of the government.
How innocent are the protesters showing up and hiding behind the First Amendment when at least some of them are armed?
Your Honor, my time expired. May I answer your question?
Yes, please.
We do not believe these individuals are hiding behind the First Amendment, Your Honor. Rather, they are the very individuals that the First Amendment was created to protect.
Is the fact that several of them were armed going to the protest evidence of a nefarious intent?
We don't believe so, Your Honor. It could be evidence of simply that they wanted to defend themselves. It wouldn't point to evidence that they intended to create any violence that resulted, and nowhere does it record that they used the weapons they were concealing.
Thank you, counsel.
Thank you.
Is respondent ready?
It's petitioner.
Oh, you guys go, okay, sorry. I kind of prefer the argument to argument. Keep track.
Mr. Chief Justice, Honorable Associate Justices, and may it please the Court. My name is David Brummond, and I rise to address the issue of the unjustified search and seizure of Taryn Bellator's personal property. As per Brigham City v. Stewart, the touchstone of the Fourth Amendment is indeed reasonableness. But that reasonableness is not found by placing loose standards of conduct on officers, as we see in the instant case. Instead, it is found by placing reasonable restrictions before officers are allowed to enter a protected area and perform an independent search. Because those requirements are failed in the instant case, we would request that the lower court's ruling be overturned for two reasons. Firstly, Officers McLeod and Beretta lacked constitutional grounds upon which to pursue a misdemeanor into his home. And second, once inside the home, the arrest of Taryn Bellator does not grant Officer McLeod the right to perform an independent search. Beginning with the first line of argumentation, respondent will likely point to the fact that Mr. Bellator left the scene of the riot quickly and was later seen running into the campus dormitory building. But the delayed course of action taken by officers is not within
the roommate allowed the police in?
The roommate allowed the officers to enter the common area.
So let me stop you there. So you don't deny that the roommate said, come on in?
Yes, Your Honor.
Now, once that happens, is consent staged? Is it limited? Is it absolute? What happens after that? Usually the common areas.
Consent is limited to a reasonable interpretation of an individual's authority. Mr. Bellator has his own private room. He buys the room on campus. As such, Mr. Trace's consent may extend to the common area because he has common usage and authority over that area, but it does not extend to a private room owned by another individual.
But the roommate told him to go check.
Your Honor, we do not believe this is...
When he does that, under what authority do you have to say that the officer did not reasonably believe he had permission from the roommate to check his room?
Two reasons, Your Honor. Firstly, as established by Devers v. Southern University and as stipulated by both parties in the lower proceedings, a dormitory room has equal protections to a home or an apartment, and as such is a protected area. And secondly, regarding the officer's reasonable interpretation or the societal expectations as mentioned previously, there is an important note to be made regarding the facts of the record. These are not police officers, they are campus officers who are well aware of the way that the dorm rooms are structured and thus the authority that is appropriated to each individual.
Does
Therefore,
the fact that the door is ajar make a difference in terms of where the line of permission ends?
No, Your Honor. This does not show Mr. Bellator giving up his expectation to privacy within the room. As such, officers are unjustified in making an entry into a protected area.
And Mr. Bellator was in the room when they asked for this consent, right?
Yes, Your Honor.
So he didn't interfere with that consent at all?
No, Your Honor.
How does that affect your analysis?
Again, Your Honor, we do not believe that Mr. Bellator must verbally state that he does not permit officers to enter the room. He has a presumptive protection of the area that was violated by officers in the instant case. One must not claim Fourth Amendment rights. They are granted to each individual and can only be removed in certain scenarios. Secondly, turning to the issue of the seizure of evidence, we would begin by making an important delineation regarding the nature of a constitutional plain view seizure. As noted by Horton v. California, the problem with the plain view doctrine has been to identify the circumstances in which plain view has legal significance, rather than being the normal concomitant of any search, legal or illegal. Thus, the turning factor in any determination is whether officers violated the Fourth Amendment in arriving at the specific place from which evidence could be plainly viewed, thus meaning that even evidence that is eventually exposed to plain view may have been the product of an illegal search, as occurred in the case at bar. Firstly, we would turn to Collins v. Virginia, citing in part Florida v. Jardines, where the court noted that, quote, when a law enforcement physically intrudes on the curtilage to gather evidence, a search within the meaning of the Fourth Amendment has occurred, end quote. The same sentiment was expressed by United States v. Jones just 5 years later, noting that, quote, it is important to be clear about what occurred in this case. The government physically occupied private property for the purposes of obtaining information. We have no doubt that such an action would be considered a search at the time of the founding. As such, we note that Officer McLeod's actions are fully unjustified. The decision to remain behind in the room after the suspect was en route to the police station, and furthermore, his deliberate intent to search the room in hopes of finding evidence is unconstitutional. Respondents are likely to turn to the prominent case of Horton.
Counsel, I don't see anywhere in the record where the roommate or your client said, your welcome in this dwelling is no longer valid, get out. I mean, good Lord, he didn't even shut the door when the roommate was giving him access to the dorm.
Your Honor, again, we do not believe that Fourth Amendment protections must be explicitly or verbally claimed by an individual. They are assumed, and when they are violated, it is a violation of the Constitution itself. As noted by Maryland v. Buey, officers must restrict their actions during emergencies to actions relevant during the emergency itself. That case established the lunging distance doctrine, which noted that officers have the right to search the immediate area during the arrest of a suspect. Furthermore, as noted by Arizona v. Hicks, officers also retain a right to perform a cursory inspection of an area that they are lawfully within.
Are the officers reasonable in assuming that this gentleman is armed and dangerous?
We do not believe they are reasonable in making that assumption, as that would be to rule on guilt by association. It is notable that in the facts of the record, the discussion of findings of illegal weapons among Mr. Bellator's counterparts were not because of the use of those weapons or even independent findings, but instead because those individuals were being arrested for other violent acts, including attacking other protesters and tearing down property.
But if they are seeing him as inciting a riot, if the words that he said were different and caused the same outcome, and his associates are also armed, is it not fair to assume that on the part of public safety that this gentleman is armed and dangerous?
We would respectfully disagree on two counts, Your Honor. Firstly, we do not believe it is reasonable to place the same assumption that was made off of violence that resulted in arrests on an individual that specifically refrained from engaging in violence. And furthermore,
the leader of the organization of people with guns in their packs, how many would the police have to encounter before it would be reasonable, in your view, to consider that maybe he's got one too?
If there was a wide usage of weapons in order to perpetrate violence, Your Honor, I missed your question. Could you mind repeating it?
Sure. How many different members of his organization that he was the leader of would have guns in their packs? How many would be enough for you to consider it be reasonable to assume that the police should go look at your client's bag?
We believe the determination should be instead based upon two factors, Your Honor. Firstly, usage. The weapons found concealed on other individuals were not used to perpetrate violence. And secondly, the nature of the crime itself. Mr. Bellator did not engage in violence, and thus, we believe it is not reasonable for police to place him in that category that he has clearly kept himself away from. And furthermore, we note
But
that—
if he's caused a great amount of violence, at some point and he's not doing anything to restrain himself. At some point, isn't it reasonable to assume that he is dangerous?
We would respond based upon that word within your question, Your Honor, caused. It is understandable that officers did believe Mr. Bellator was involved in the violence, but we would note two factors. Firstly, it was only 24 hours after the riot that a CPD investigation actually linked Mr. Bellator to incitement of the violence. And furthermore, even though property damage at the scene of the riot was severe, Mr. Bellator was only prosecuted under breach of the peace, disorderly conduct, a misdemeanor in the state of Frankfurt. As noted by the common law interpretation contained in Lang v. California, there has always been a difference of police powers when dealing with violent felons and mere misdemeanors, thus implying an inherent restriction upon the abilities of police not only to enter Mr. Bellator's room, but also to perform an independent search. Your Honor, my time has expired. May I briefly conclude?
Yes, please.
Thank you, Your Honor. We believe that officers retained no right to enter a protected area, and once inside the area, do not have the right to perform an independent search. Thus, we petition for relief.
Thank you, Counsel. Respondent, let's hear what you have to say.
May I proceed, Your Honor?
Please.
Mr. Chief Justice, Honorable Associate Justices, may it please the Court. My name is Olivia M., and I, along with my co-counsel, Mr. Derek Sun, represent the respondent, Frankfurt State, in this case. Your Honors, my co-counsel will be addressing the issue of the Fourth Amendment, and I'll be addressing the First Amendment issue. To protect life and property, the right to free speech is subject to accepted and reasonable limits. Frankfurt Statute Section 867.03 is one of those reasonable exceptions. Bellator's speech did not simply cause dispute or unrest, but rather instigated a 4-hour upheaval causing $1 million in property damage and hospitalizing students. For 40 minutes, Bellator had every opportunity to cease his chant after his words caused the peaceful protest to rapidly devolve into a raging riot. This court should uphold the decision of the Supreme Court of Frankfurt because Bellator's speech falls under the constitutionally unprotected area of incitement. Pursuant to Brandenburg v. Ohio, there are two key requirements for incitement, as my colleague mentioned. One, the speech must be directed to inciting or producing imminent lawless action, and two, it must be likely to incite or produce such action. Intent is...
Help me understand this. As I'm reading the record, it says, "From sea to sea, Atlantis shall be free."
Yes, Your Honor.
You're calling for freedom. Isn't that what this country's founded on? How is that not just a patriotic, loyal statement of a group that he belongs to?
Because of the historical meaning and the intent in this context, Your Honor.
What authorities do you have for purposes of finding this objective meaning that's so terrible? Is there like a naughty word dictionary that we can consult?
No, Your Honor, but there is the facts of the record on page 4, paragraph 2, which notes that the original meaning of the chant is used to intimate the elimination of the Olympian state entirely from the island. And as you yourself noted, Chief Justice Coxon, this is an ethno-state, and he groups the people with that. As Hess v. Indiana...
But we know that on a college campus, they can't eradicate the existence of a people group. So why should we chill speech here?
Because, Your Honor, it is directed against the counter-protesters specifically. As you stated, they cannot eradicate the government as a whole, and that leans more in favor of respondent, because it means that his intent is against the people who he can affect, the counter-protesters right in front of him. In Counterman v. Colorado, this court noted that intent is a critical aspect of the prong directed to, echoed in Hess v. Indiana and NAACP v. Claiborne cited in Counterman, which prevents a heckler's veto, the chilling effect, and government overreach, and ensures that efforts to prosecute incitement do not bleed over into the dissenting political speech at the core of the First Amendment. Now, the question is...
But the ambiguity of his pre-chant statements are ambiguous, so how can we infer intent from that?
Because there is enough context, Your Honor. Turning to his pre-chant statements, we need to make these genocide murderers feel the violence they've inflicted and death to the murderers. We believe that there is clear context in this case.
But the nature of the violence wasn't specific to individuals. It was more like throwing bricks and starting fires. That is different than me making a genocidal murderer pay and targeting an individual. Would you not agree?
Yes, Your Honor, we do agree, and that's why his chant didn't say we need to make this genocidal murder. He said these genocidal murders, referring to the group that composed of individuals of counter-protesters.
But even so, the violence wasn't targeted toward the individuals or this group of individuals, but rather mayhem and riotous, violent behavior, but not targeted violence.
It was mayhem targeted against all of these counter-protesters. As reported by page 4, paragraph 2 of the records, the protesters hurled bricks and glass bottles at each other, which were at the counter-protesters. It was targeted because, of course, they weren't throwing it at their colleagues. They were throwing it at the opposing side, which is the intent of Bellator.
How is that different from Hess, though? Because the court specifically noted that in Hess, this statement, we're going to go back and take this street, wasn't directed at anyone in particular, but just a broad group or a broad purpose. And they said that this was totally reasonable. How is that different?
Because, Your Honor, in this case, Bellator did state it over the protesters. In the case of Hess, the petitioner stated, we'll take this street later, but he wasn't directing it at anyone. He was simply saying it to the authorities, to himself. He wasn't directing it at counter-protesters. In this case, Your Honors, in stark contrast, page 4, paragraph 2, notes that Bellator stated over a megaphone, which is clearly intent that is directed against them, over the crowd.
You know, if this phrase is so objectively horrific that just turns the senses, why did the police let this go on for so long? If it was just such an obvious wrong thing that he was saying that is so offensive and violent-inducing, is the police have some culpability here aside from the Fourth Amendment issues?
No, Your Honor. We believe that, first of all, the police did they did warn Bellator, as reported by Appendix B and page 6, paragraph 3. But also, as noted in Gregory v. Chicago, cited in Bible Believers, of course the police are not supposed to completely silence the speaker, though they may warn him. As they did clearly in this case, they are not culpable because they're supposed to be quelling the riot, which eventually they did, Your Honor. By turning again to the ambiguity, supposedly, of his pre-chant statements, we believe that there is enough context in this case. My colleague argued that he didn't fight himself. But, Your Honors, this is clearly something that this court has never held under incitement. The entire purpose of incitement is not that you physically were attacking yourself, but that you incited others to attack. Fighting is not a requirement. It is inapplicable.
So would the respondent advocate for just a blanket ban on the use of the phrase?
Absolutely not, Your Honor. And that is because we must consider the specific context in which it was used and the intent. We are not allowed to ban speech, and nor would we want to, just because of the content of the words, a content-based restriction. But as this court noted in Snyder v. Phelps, a context is crucial for intent, and states that in considering content, form, and context, no factor is dispositive.
But then you say that no, we don't need to ban it, which would go to the likelihood. So then we're only determining intent?
No, Your Honor, because context plays into the likelihood as well. Stating this chant in just any context, of course we cannot ban that. But in this case, it was inherently likely to, given the context of this specific situation. As you noted, Chief Justice Coxon, several of his protesters were armed with bear mace, bowie knives, and brass knuckles, as reported by page 5, paragraph 1. And this was not just to defend themselves, as my colleague noted, which we can see in the end. But furthermore, Your Honor, in this specific context, it is inherently likely to incite violence. Going back to Hess, which my colleague mentioned, and you, Associate Justice Burson, referenced as well, in Hess, the petitioner said, we'll take this straight later, which this court ruled was not imminent, was not producing imminent lawless action. That is because no one would hear his words, let's take it later, and respond with immediate action. In contrast, in the case at bar, Bellator did not give an explicit time frame, but regardless, his words produced an imminent response. The question before this court is not whether the words themselves contain a time frame and are imminent, but whether the words themselves provoke an imminent response, which is exactly what we see in this case, and it is inherently likely to have occurred.
It took 40 minutes. How is that imminent? I I mean, he kept saying it over and over and over again. And the police let it happen. Like, there's a burning fire. Hey, police, why don't you do something about it? No, we're gonna wait until people start getting hurt. It just doesn't make sense to me.
We disagree, Your Honor. It took 40 minutes that he continued chanting despite seeing the violence erupt and police warnings, but police did warn him and he continued chanting. And moreover, it was immediate. There was immediate agitation as reported by page 4, paragraph 2, and within 3 to 5 short minutes, they erupted in violence. My colleague argued that this was not imminent. However, in NAACP v. Claiborne, on page 291, this court said that weeks or months later is not imminent. 3 to 5 minutes.
So should the police, should Mr. Bellator stop chanting because the police tell him to?
Your Honor, he is not legally required to, but the fact that he chose to continue chanting despite police warnings and violence points toward his intent. Because, Your Honor, if a reasonable person were chanting something, a political slogan, with no intent of violence, and the violence suddenly erupted as a result of his speech, and he was warned by the police of this, he would not continue chanting. He would stop.
What if Mr. Bellator's youth and inexperience and passion about the topic sort of prevented him from realizing that he's responsible for causing the violence?
That would be possible, Your Honor, if not for the fact that police explicitly warned him, again, according to Appendix B. In this case, police warned him, and a man of average prudence would stop his chant if he saw that it caused violence and had no violent intent.
So a man would, but what about a young person?
A young person as well, Your Honor, especially if the police pointed out that he was the one causing the violence.
What about the evidence that our brains, especially men, are not developed until they're well into their 40s?
Chief Justice Coxon, my time has expired. May I briefly respond?
Please answer,
Thank you, Your Honor.
if you dare.
Associate Justice Corley, are you referring to the fact that he was not aware that he was causing the violence?
Yes.
Your Honor, again, we would point to the fact that police explicitly warned him. Even a teenager in high school, Your Honor, if police told you that your speech was causing violence, although your brain might not be fully developed, you would still at least know that police are telling you that it was causing violence. Even if you were completely blind to the violence around him, that he was ducking from bricks being hurled over his head, according to page 4, paragraph 2, police made clear that they wanted him to stop because he was causing the violence. Your Honors, the petitioner wants you to see a record of coincidences. That Bellator happened to mention violence in his pre-chant statements, and then continued chanting when violence occurred. Not all speech is free speech, and this court has never forced the government to stand idly by and allow harm to life and property. In this case, Your Honors, his own pre-chant words and his continued chanting despite police warnings is clear intent, clear proof of his intent. And therefore, we urge this court to uphold. Thank you.
All right, Mr. Fourth Amendment.
Mr. Chief Justice, Honorable Associate Justices, and may it please the court. My name is Derek Sun, and I will be addressing the Fourth Amendment issue. Unlike a child's game of tag, the law does not reward the evasive runner. Those who flee the police do not win anything, certainly not additional rights, because they began their flight in their home. Suspects who flee a lawful arrest have only themselves to blame for the officer's ensuing entrance into their residence. By overturning this clear standard, the petitioner's straitjacket forces officers to naively ignore clear inferences from behavior. Thus, we ask this court to affirm the lower court's decision, because escape allows entry in this case, and the seizure therefore was justified under the plain view doctrine. To the first point addressing the entry, to clarify, my colleague's objection wasn't upon the initial entry, but most focused upon the staying behind aspect of Officer McLeod's actions. Nevertheless, we will briefly touch on what allowed officers entry in the first place to Mr. Bell.
I want to hear the second one.
Yes, Your Honor.
Why did the dude get to hang out and at some point, in your view, would make that unreasonable? It's 90 minutes, an hour and a half. Wait, at what point does it become unfair for this guy to just, move into the room?
Your Honor, I believe it's more of a sliding scale than a direct rule as to what.
Just change the facts of this case.
Sure, Your Honor.
Had he remained by X more minutes, it would have been too much. Just tell me what that number is.
Your Honor, first to clarify, we don't have the number as to how long Officer McLeod stayed. We do know that he, quote, briefly scanned the room. And according to Appendix H, the layout of the dorm room would mean that Officer McLeod was essentially walking back from the window, back out the door, and he scanned the rest of the room as he saw it. So that most importantly accords with the respondent's interpretation of the facts. The Officer McLeod wasn't staying behind for hours on end, and he just fell asleep in Mr. Bellator's bed. But rather...
So then, with Mr. Bellator being detained, what is the harm in, at that point, having the officer go get a search warrant to search the room?
Your Honor, first to clarify, as this court held in King, this court has never held officers to a standard of obtaining a warrant at the earliest possible time. Instead, in this case, the plain view exception, in the words of Hicks, allows officers to take actions beyond the original scope of the search. To hold for petitioner would essentially obliterate this entire doctrine, which allows there again to be that independent action beyond the original justification for the entry. In this case, exigency.
How much time passed between when the police lost him to when they got to his dorm room?
Your Honor, that was about 4:45 p.m. when they lost track, and about 7 p.m.
More than 2 hours, and you think the exigency maintained that entire time?
No, Your Honor, we aren't claiming that the 4:45 pursuit was the exigency that allowed entry. It certainly is a factor pointing towards Mr. Bellator's ability and willingness to flee the police, but it's not by itself the exigency that we would point to. Rather, the reinitiation of arrest at 7 p.m. when officers reasonably believed that a suspect who looked like Bellator was fleeing directly away from them, thwarting a lawful arrest, in the words of Santana.
Yeah, he went home.
No, Your Honor. From the point of view of the officers, which we consider Fourth Amendment cases by, it seemed as if Mr. Bellator, who was a suspect who had already fled the police, was again fleeing directly away from the officers and into his dorm room.
If I flee the police on foot when I leave this courtroom today, what rights do the police officer have to search me in my car if I'm running to my car?
They don't, Your Honor, because of course, I hope, Chief Justice Coxon, you haven't been made aware that you're under arrest for a crime. However, in this case at 4:45 p.m., Mr. Bellator clearly fled a lawful arrest being initiated. He saw multiple other protesters being arrested, in the words of page 5, paragraph 1, in the exact time and place that he was, and then fled through a wooded hedge away from officers, not the actions of a person going about his business or going home.
But the record isn't actually clear that we know for certain that was Mr. Bellator, isn't that correct?
No, Your Honor, we don't know specifically if it was Mr. Bellator. It did resemble him from behind.
And, what if Mr. Bellator is in his room believing that now he is being unlawfully pursued? Doesn't he have the right to then seek escape?
Your Honor, turning towards the officer's perspective, as the petitioner's standard would essentially force officers to see a record of coincidences. Someone who resembled Bellator happened to flee the police, then a window happened to open in Mr. Bellator's dorm room, and the window was actually open, according to page 5, paragraph 2, once the officers advanced into the room. Clearly, the most reasonable interpretation from the officer's perspective is that Mr. Bellator was fleeing the police, fled into his room, then fled or tried to flee out the window.
So you're saying running back to your dorm room is the exigent circumstances that allows them to just waive all Fourth Amendment protections?
No, Your Honor, of course not.
What if he had walked briskly?
Your Honor, to answer both of your questions, I believe, we can turn towards the fact that the window did open on page 5, paragraph 2, once the officers were lawfully in the common area.
Was he a flight risk?
Yes, Your Honor.
Out of the country?
No,
For a
Your Honor.
misdemeanor? I don't understand. Quick! He did a misdemeanor 2 hours and 15 minutes ago. Why not sleep on it, get the warrant, get your ducks in a row, have a nice breakfast, and then go figure out where he is? I just don't understand what passion was needed for this misdemeanor.
Your Honor, firstly to address the flight risk question and then to address your observation about the level of the crime. Lang v. California controls this case. And 4 years ago, this court clearly recognized in that case that we can presume officers have an exigent circumstance when a suspect flees the home. Of course, an extremely minor crime, One that's non-jailable, in which the government has no interest to apprehend the suspect, wouldn't allow entry. But this crime that Mr. Bellator committed has a maximum of 6 months in jail, and as Lang v. California noted, misdemeanors as a whole can only be punished up to 1 year in jail. This clearly isn't a minor crime for which the government has no interest to outweigh the suspect's diminished privacy interest.
Wasn't the charge breach of the peace?
Yes, it was, Your Honor.
And a misdemeanor.
Yes, Your Honor, it was.
So how can that possibly be so serious to justify an intrusion into one's home?
Your Honor, because the escape from the home exigency that Lang recognized and reaffirmed doesn't turn upon the misdemeanor felony distinction. Lang only held this for hot pursuit into a home, not escape out of it. The line for escape should be much less significant because of the presumption of exigency. The court in Lang, in 5 separate instances, recognized escape from the home as the same level of exigency as other exigencies like harm to the public and evidence destruction. It's either all of them or none of them turn upon the misdemeanor felony distinction. And because of this—
Lang is talking about hot pursuit, correct?
Yes, Your Honor, and the holding of Lang was that absent other exigencies, like escape from the home, the officers cannot enter for misdemeanor pursuit. This was a key line of reasoning in the holding of the court, hence why it was mentioned 5 separate times in the context of the majority opinion, and separately by both major concurrences from Chief Justice Roberts and Associate Justice Kavanaugh. So
why should escape be considered an exigency with basically a nonviolent crime?
Your Honor, because that's what this court held 4 years ago in Lang. To clarify, the misdemeanor felony line was drawn by that court, yes, but that only applied toward hot pursuit into a home where there aren't the 4 walls to box the suspect in and tell us that the suspect is guaranteed to be in his home as long as we watch the exits and wait for a warrant. By contrast, in escape from the home cases, there are not 4 walls to box the suspect in and allow the police the alternative of surveillance and waiting for a warrant. These 2 exigencies are separate. One is not a serious exigency in misdemeanor pursuit cases. The other one is. To rule otherwise would fly in the face of this court's clear precedent in Lang v. California, which described escape from the home as a, quote, good reason to enter, a, quote, emergency, a, quote, exigency, a now or never circumstance.
Now, the roommate allowed access, but really limited what they could do. You can go check and see if he's there, not search his room, not poke around in the paper bag and looking for guns. So do you think the consent that he was given is a binary one, which is you may only see if he's there and nothing else? Or once he's in, the police officers can do whatever they want?
Your Honor, the respondent only contends that the consent allowed entry into the common area, which I believe my colleague and I actually agree upon. We rather turn towards the escape from the home exigency to allow the further entry into Bellator's dorm room. And the fact that
But weren't they already in the dorm when they heard the window open?
No, Your Honor, they were in the common area of the dormitory, and then they heard the window opening, after which they entered into Mr. Bellator's dorm room. The fact that the officers, in the words of my colleague, had the intent to stay behind also flies in the face of this court's precedent, valuing an objective officer's standard for even-handed law enforcement, as this court held in King. Overall, Your Honor, there was an exigency that allowed entry in this case, and the protections of the Fourth Amendment shouldn't be allowed to be used to pervert justice. Thus, we ask the court to affirm.
Thank you, counsel. I think we have 3 minutes.
Permission to proceed?
Please.
Mr. Chief Justice, Honorable Associate Justices, and may it please the court. 2 lines of response, beginning with the First Amendment issue under the prong of intent. We'd begin by noting the lack of direction behind Mr. Bellator's words, and thus would request that the misinterpretation of a crowd is not a valid reason to punish the speaker. Let us even take the chant at its most violent, calling for violence at an island hundreds of miles away, not at an American college campus. The same sentiment can be expressed additionally to the pre-chant statements uttered by Taryn Bellator. To rule against the petitioners on this matter would be using a private statement utterly divorced from context to read into the mind and motivation of the speaker. American college students are not genocidal murderers, and thus any violence implicit or explicit in Mr. Bellator's words is directed outside the college campus.
So what if the pre-chant statements were more specific? Would that go to proving his intent?
Advocacy is an important consideration. We do believe that when advocacy is explicit, an individual's First Amendment rights may be reasonably restricted. Yet the advocacy in the instant case is vague and directionless. Turning to the Fourth Amendment issue, we'd begin by addressing the search of Taryn Bellator's room. A brief Fourth Amendment violation is a Fourth Amendment violation nonetheless. As respondents did not heavily interact with this concept, we would note that the search must be overturned, and as such, each of the criminal counts against Taryn Bellator must be rescinded.
So respondent is saying that it's not about permission to enter, but rather the escape causes the exigency, not the permission. What is your response to that?
We would note two things, Your Honor. Firstly, we do not believe that escape is a valid exigency, but furthermore, even if escape allows officers to enter the room and arrest Mr. Bellator,
Why is escape not a valid exigency?
we believe so because it simply lacks application to the case of a misdemeanor. Respondent cited Lang v. California as a controlling case, a case that rejected a categorical rule and remanded. But furthermore, in the words of Lang v. California itself, those suspected of minor crimes may flee for innocuous reasons and in non-threatening ways.
Well, hold on. So he ran away from the police from the protest. He ran away from the police to get into the dorm room. Upon hearing the window open, doesn't it seem reasonable that maybe he's at it again?
We would respectfully disagree, Your Honor. Silverman v. United States, as cited within Illinois v. Rodriguez, clarifies that individuals retain the right to retreat into the home and thus be free from unreasonable government intrusion. Lang v. Santana carved out a singular exception, that being when an individual's retreat is to avoid a lawfully communicated and clear attempt at an arrest. Yet that is missing from the facts of the record. As such, Mr. Bellator does reserve the right to flee from police, even though he may not flee from an arrest. Because we believe our client's First and Fourth Amendment rights were violated in the instant case, we would ask that the lower court's ruling be overturned.
Thank you, counsel.
The Honorable Court is now adjourned.